I'm actually going over Civil Rules of Procedures, and it's a course book by Walters Cooler. You can look it up, I'm sure. And this certain subject I'm researching at the moment, Civil Rule 15A, which is leave to amend, and it says that it shall be freely given when justice so requires. This mandate is to be heeded. And then it goes on to say if underlying facts of the circumstances relied upon by a plaintiff may be proper and subject of relief, he ought to be afforded an opportunity to test his claim on the merits. So you should be given an opportunity to correct any defects in your current complaint, current pleadings that you have on file within the complaint. I understand that you have 15 days after an answer has been provided to request to the court for leave to amend on the complaint unless justice otherwise requires. So I understand that this is based on a case called Foreman v. Davis, 371 U.S. 178 out of 1962. It is a court case that is an appellate review, and the appellee sought appeal and was found favorable to affirm it as a standing, and it's an underlining framework of a precedent case that is all quoted for leave to amend. Moving on in that section at 182, it goes on to say that the burden is on the party opposing the amendment to show that such prejudice would be resulting from such pleadings or such motion, and the motion for leave to amend and the trial court must inquire into the case or the issue of prejudice to the opposing party in light of the particular fact of a motion to amend pleadings noted in Foreman v. Davis. Allowance or denial of leave to amend lies within the sound discretion of the trial court and is reviewable for abuse of discretion. It is evident, district court, that the exercise of ruling on the defendant's motion for leave to amend is searched for the record for evidence of bad faith prejudice or undue delay which might be sufficient to overbalance the mandate. Also, outsource the other party their sufficient access to unlimited resources. And this is a fact. You know what? Check this out. Congress has admitted this. Congress has actually acknowledged this right here. This is United States Code annotated Title 23. So this is the federal code, and this is positive law. So it is a disadvantaged business enterprise, they call it. And that's anyone by the findings of Congress out of Public Law 114-94 Division A Title 1 subsection 1101B annotated on December 4th, 2015. One findings that Congress finds: A, while significant progress has occurred due to the establishment of the disadvantaged business enterprise, discrimination-related barriers continue to pose significant obstacles for minorities, men and women, business-owned enterprises who seek to do business in a federally assisted surface transportation market across the United States. B, the continuing barriers described in subparagraph A, the merit, the continuation of the disadvantaged business enterprise program. And C, Congress has received and reviewed testimony and documentation of race and gender discrimination from numerous sources, including congressional hearings and roundtable scientific reports issued by public and private agencies, news stories, reports of discrimination by organizations and individuals, and discrimination lawsuits, which now shows that race and gender neutral efforts alone are insufficient to address the problem. Indeed, the testimony and documentation described in subparagraph C demonstrates that the demonstration across the United States poses a barrier to full and fair participation in surface transportation related business enterprises for men and women businesses which are owned by a majority or minority of businesses and owners, and has impacted a firm development and many aspects of disparagement on the surface transportation related business which in the public and private markets they operate. In many aspects, the testimony and the documentation described in subparagraph C and paragraph E provided a strong basis that there is gender discrimination in the surface transportation related business enterprise. So they're actually acknowledging that there's not just race discriminations or nationality discriminations on the surface transportation related business enterprise. They're also acknowledging that there's gender neutral aspects involved, which are discriminations, and in general is a small business concern, because the term small business concern means any small business, as the term is used in Section 3 of the Small Business Act of Section 15, 632. I don't have that book available right here, so if you're interested, I've already done so. You can go search for yourself, Small Business Act, Title 15, USC 632. And you'll find this same information here as you find in Title 23, annotated on the highways. So it goes on to talk about exclusions in the terms of small businesses, and the term small business concern does not involve any concerned group or concern controlled by the same socially and economically disadvantaged individual, or individuals that have an average annual gross receipt during preceding 3 fiscal years in excess of $23,980,000, as that may have an average or may be adjusted annually by the Secretary of Transportation for inflation. Oh man. So they're actually acknowledging, whether if you know it or not, they're talking about the small business disadvantaged business enterprise. And it can only be one thing. Only one thing. Those who go out on the highways in the skies of false impressions, offering a service of public safety that's actually for no safety other than their own safety, which puts everyone else at a total disadvantage of your word against mine, and my word is final. Because I have the capability to be able to outsource you, as it was saying over here.